Well, good morning, everyone. My name is Nicole Forbes. I'm a family law lawyer here at Orr & Reno. And I want to thank you all for coming and thank the Chamber for having me today. Today, I'm presenting on protecting business assets in divorce and at death. For those of you who have not attended a breakfast series presentation before, it's a pretty casual format. I'll be talking, but it's a pretty open conversation. Feel free to ask any questions as we go. There will be some general Q&A at the end. For those of you who want to wait till the end, that's fine. And then if we have any more remaining time, we can do some more networking. There we go. By way of background, I've been practicing law for roughly 8 years. The majority of my practice has focused on family law, and in the last 2 years or so, it's been kind of exclusively what my practice is. So I handle a lot of divorces, which more often than not, for us, involve a business. Either our client's the business owner, the other side's the business owner, or they own a business together. So we work a lot on these issues from that back end, but also draft prenuptial agreements and postnuptial agreements, sometimes to protect those business interests at divorce and at death. So today, those two instruments will be a big part of what we talk about. They often are referred to as prenups or postnups for short, and I may use those terms interchangeably, and I probably already have because they're just terms of art that are pretty common. We'll also spend some time talking about alternatives to the agreements, other ways that you could safeguard these assets in divorce or at death, because as you may imagine, a prenup or a postnup is not necessarily always something that everyone is on board with, that both people want to do. And even if they are, it can be somewhat awkward to spend your wedding planning in part with lawyers negotiating and talking about what might happen if you divorce or die. We'll also go over some takeaways. And again, although there'll be time at the end for questions, I do invite you to ask them throughout the presentation if you prefer that. Sometimes I find that can kind of add to the presentation, and you often answer questions that other people had anyways. But overall, the presentation is intended to be a summary of the issues. And although it might be some general guidance, I am a lawyer, so I have to tell you that it's not a substitute for legal advice. But if you do have some specific questions, feel free to reach out to your lawyer or to me offline, so to speak. And then before we get into the presentation, does anyone know what prenuptial and postnuptial agreements are? Generally speaking, feel free to share. Okay, all right. See. So essentially, and for our purposes today, prenuptial and postnuptial agreements are contracts that do the same thing in most instances. They define rights and responsibilities during marriage as to assets, income, and debts in a marriage termination event and or at death. Sometimes people want to provide for divorce, they don't want to provide for death. Usually they're providing for divorce and not death. That's normally what they want. But for some people, especially if it's their first marriage, they might just stick to divorce and not worry about what happens when they die. They also are treated with heightened scrutiny under our law in comparison to other contracts because of the nature of the contract. You're dealing with marriage and equitable rights that stem from that marriage, as well as the relationship between spouses. Our law sees spouses to have a somewhat fiduciary relationship with each other, as opposed to general, parties that are unrelated that may contract. The difference is when the contract occurs. So you might have gathered that prenups happen pre-marriage to be effective on marriage in most instances, and postnups are entered in after the parties marry. There are added nuances between the two that are outside the scope of this presentation, but if you find yourself or someone else interested in these type of agreements, you want to maybe ask a lawyer or get some more information. You'll notice on the slide that I use a marriage termination event. And that includes divorce, which is probably the most common event that we're planning for. But you also may get other legal terminations like annulment, Legal separation is often called a marriage termination event in the contract itself, even though technically you're still married, if you're legally separated. And you can qualify it in different ways. Oftentimes, a marriage termination event is triggered just by a filing of something like that, as opposed to the actual divorce. So typically in the agreements, the parties are defining what marital property is, ours, so to speak, and what is separate property, mine or yours. The distinction is important for some reasons we'll talk about in a couple minutes in the presentation, but a common structure and kind of like a basic prenuptial, postnuptial agreement that we talk about is that anything that the parties bring individually before the marriage, anything that they inherit before or during the marriage, anything that they might be gifted, anything they keep in their individual names, individual bank accounts, is separate. It's excluded from marital assets and excluded from consideration in divorce, and the parties are able to manage it freely in their estate plan with regards to who they're leaving certain assets to. Anything acquired jointly during the marriage, held jointly, is subject to division. It's marital property, and typically, a general structure, those assets go to the surviving spouse at death in the estate plan. You can do really a lot of things in it that are pretty creative. Sometimes it won't be that rigid. It will be anything that's acquired during the marriage is marital property, regardless of how it's held, commingled, things like that. But as you might guess, often a business is defined as separate property. Often that's what they really want to protect. That's something specifically carved out, if not already in some general language. There are a lot of reasons why parties may wish to enter into a prenup or a postnup, but they all tend to fall into three overarching categories. They're trying to minimize statutory consequences, which in divorce means property division and alimony. At death, it's what we call the elective share, limit risk, and manage wealth. So first, one or both parties are trying to minimize those statutory consequences that are outlined right there. And so in divorce, again, it's property division. How are parties dividing their assets and liabilities? In alimony, who, if anyone, is paying an amount of money to the other for living expenses? At death, the biggest scheme that people are likely trying to avoid or temper is the elective share, which allows a surviving spouse to elect to take a share under the statute of the deceased spouse's estate versus whatever might have been left for him or her in a will. And so presumably, if you're electing the elective share, you're getting a larger portion under the statute than you are in the will. Otherwise, you probably wouldn't be electing it. And it's very fact specific. It's a long statute that gives a certain percentage, a certain share to the surviving spouse based off of other people who would have survived the deceased. So for example, it's not uncommon for a party who is to be married to want to safeguard their business in the event of divorce by making it separate property as defined by the prenuptial agreement. If they do so with well-drafted language, that asset is off the table in an event of divorce, presuming the agreement is enforceable. So that party will be awarded it. Most likely that's what the prenup says. That asset will not be included in the marital estate. If the prenuptial agreement also has an alimony waiver, any income generated from that business to the business owner is protected as well, so long as the business owner keeps it within the bounds of their separate property under the agreement, or if the prenup specifically carves out those business profits as separate property, and the funds are protected, and with the similar caveats, you're protecting the asset, you're protecting the appreciation, you're protecting the income that could be generated off of it, depending on how you structure it. And again, if it's enforceable, in terms of the court finds that it's an enforceable contract and it's fair, that's kind of the very general way of looking at it. The court's going to implement it. It's just going to be a matter of what does it say, what falls under separate property, what falls under marital property. The business is separate. Okay, that goes there. Without an enforceable prenuptial agreement with this type of language, the result is different and often not what people may expect or not what they want, which is why they do it. So on the property division side, the business will be included in the marital estate and subject to division, because our statute essentially says we include all the property and all the assets that belong to either or both parties, regardless of title and regardless of when it was acquired. It doesn't matter if the asset was premarital. It doesn't matter if the asset was inherited. It doesn't matter if the asset was a gift. And it doesn't matter if the asset came from a family transaction or in some way it came from the family. Now, those factors do matter when the court's deciding, okay, everything's included, who's getting what, and that's all important, because the court is going to equitably divide property. And the court will presume that an equal division of the estate, not necessarily every asset, is equitable unless certain statutory factors suggest otherwise. So what most people worry about in this context is, I don't want to be in business with my ex-spouse. I don't want my dad to be in business with my ex-spouse because, maybe you own it together. And is that a possibility? Yes. Is that likely? No. Because the courts are really trying to unwind people, trying to limit how much they need to talk to each other after the divorce. And they're also going to respect how things were acquired, how things were maintained. If the business owner is the person that managed the business, that's their livelihood, more likely than not, they're going to get it. What is going to happen, though, is that business interest will be valued. That value will be assigned to that business owner, so to speak, meaning that likely, because typically businesses tend to have more of significant value than other assets in a marital estate, it's going to be kind of going on his or her side of the scale, so to speak. And so if you're getting that larger value, other marital assets might need to be awarded to the other spouse to get towards that equal division or a different division if the court has found that it's appropriate. And so from that perspective, if you want to really kind of make sure that it's excluded and that you don't think it's fair that business asset that could be of, maybe you're the fourth generation owner and, that's a lot of value that is important and that you should take, but maybe it's not really fair that, $500,000, $1 million is going on your side of the line and you're kind of losing some cash, losing some real estate, things like that. With regards to alimony, presuming the non-owner has a need for alimony and the owner would have the ability to pay it, most income the business owner is entitled to, like owner draws, regular pay if the owner takes via W-2, business profits received, and any profits that the business owner maybe should be taking but stay in the business, that could all be used as income depending on the circumstances for an alimony amount. Under our statute, absent special circumstances, the maximum award right now, it's a formula amount, is the lesser of 23%, the difference of the parties' gross incomes. There's certain deductions, certain additions, but that's kind of the Cliff Notes version of it, or what the actual need is. What expenses is that person not covering that could be used, alimony could use to supplement. And in terms of the length of the award, it's going to be no longer than half the length of the marriage. And alimony can be modifiable within 5 years of the end of the order in certain circumstances. So it could go longer depending on what happens after that divorce order. So the consequences of having a business asset defined as separate property in an enforceable prenup or postnup with the appropriate language can make a big difference with how it's treated, how that business owner, what type of deal they get, so to speak, in the divorce, and how those statutes can impact that. The second, limit risks. If a prenuptial or postnuptial agreement is well drafted and enforceable, the settlement of property division and alimony in the event of divorce is already determined. The parties know what to expect. They're more likely to settle, thus limiting the time and expense of the process, and the likelihood of a rogue judge, so to speak, is decreased. Because ideally, the judge's role is very limited. It's minimal because you guys agreed to this. It's important, you're not contesting the enforceability. So again, it's just, we have our settlement and it's how are we implementing it? This is what you guys already agreed to on these issues. This could save each party tens of thousands or hundreds of thousands of dollars, depending on how many issues they're involved in attorney's fees. So people who are business minded tend to want to complete the process efficiently and effectively, limit the need for tens of thousands or hundred thousands of dollars in attorney's fees. So a well-drafted and enforceable prenup or postnup can go a long way to reach that goal. Third, manage wealth. Most of the time, this is motivation for people who are trying to protect family wealth, like a closely held business, or provide for children of a prior relationship, including those who may be or are about to be actively involved in the business, might be getting not only involved in the operations, but eventually taking it over. And so it can be part of that succession planning as well. And so you may be asking, okay, but why would you need a postnup if you already have a prenup? Why wouldn't you take care of it before? So there's a number of reasons why people would get a postnup, whether or not they had a prenup to begin with. Three common ones are: first, there was no prenup, time could have run out to get it done, which can be another presentation in and of itself. So the parties try to get a postnup afterwards because they couldn't get it done beforehand, and that presents its own issues with regards to enforceability. Second, there was no business at the time of the marriage. That's common as well. This is a business that either it was acquired during the marriage, it was created during the marriage, it was something that wasn't considered at that time, but these same tensions remain, these same concerns about protecting it. So there wasn't anything protected for, but now there is. The last one, there's a change in a relationship. For example, most postnups in general come from there being a marriage breakdown in some way, like people just not getting along, maybe there was an affair, and there's an agreement to stay married regardless of all of this. And in those circumstances, part of the agreement to stay married is often, we need to fix what happens with the divorce comes, and that would include, what happens to the business. So essentially, one party made a mistake, the other is willing to forgive them and stay, but that forgiveness comes at a cost. There needs to be some consideration for, I'm forgiving you, if this happens again, I'm not going to be so forgiving, and I need to make sure that I could have divorced you right now because I'm not. We need to kind of structure what that looks like. Excuse me. So I already kind of gave you the answer a little bit in the agenda slide with regards to that there are other ways, other alternatives to protect business assets besides a prenuptial agreement or a postnuptial agreement. Does anyone have any idea of what they may be? Yes, that's one. Yep. Yeah, so trust is a big one. So the alternatives, so there are kind of three to consider today. First is nothing. The parties can always do nothing. People often forget that is an option in a lot of situations. You can always do nothing, including, getting a prenup or getting a postnup. Second, an existing irrevocable trust may already provide adequate protection. And third, the existing corporate documents themselves, the articles of incorporation, operating agreements, things that formed the business and what people are operating under, may already address the concerns as well. So you might be able to skip that piece altogether. And what alternatives make sense typically depends on why the business needs to be protected. So when someone calls me with regards to a prenup or a postnup to protect business interests, typically ask, why, what's the business, what's the structure, how's it acquired, what are your main concerns? There's a variety of answers, but three are instructive. So first, the potential client may tell me that they're the business owner, they're concerned that they'll lose their business. The court will just give it to the other side if they get divorced. It's their livelihood, it's what they worked for. In that case, I'd explain kind of what we just talked about before. Is that possible? Yes. Incredibly unlikely that a court would do that unless circumstances have really changed by the time you get to the divorce stage. And whether that makes sense, sometimes they say, okay, well, then I don't really care. And then we kind of talk about everything else, but it will be included. You'll value it. It'll make it more expensive. You'll have to get experts, things like that. And they still may forego it, knowing that they're going to forego these protections, because they weigh that against how uncomfortable the process could be, or that they just want to marry someone who doesn't want a prenup, and they value that more. And that happens, probably more than people would think, when people want a prenup, and then eventually they just determine, I'm just gonna roll the dice. This person doesn't want it. I really want to marry them. I think it's gonna work out. And if it doesn't, I'll deal with it then and go through the process like a lot of people do. Second, the caller might not be the person getting married. It's not uncommon that that person is a parent. For example, maybe they're the current business owner, they know, and the one of the people married might be involved in it already or may not. They know it's coming. They don't know what that would mean if there was a divorce, or if their child were to pass away. And so they automatically are thinking, I don't want my soon to be in-law to get anything on the business. My family's worked on it. Again, you might be getting those fourth, fifth generations, and they can't even imagine, it coming through. And again, you kind of have that same conversation of, well, if that's your concern, this won't really matter, but what do you have in place, right? So if you own it now, what does your estate plan look like? Is it something that's already there? Do you have a revocable trust? For example, some people do have irrevocable trust that hold the business asset to safeguard it from creditors while providing a vehicle to benefit their children. And so if the business is already in irrevocable trust with what our law calls a spendthrift provision, it's a part of our statute that's very specific on what the language needs to be. And if it falls under that, our statute specifically excludes it from the marital estate. So if you already have that, then you're covered. That doesn't mean that once the child or the beneficiary gets something outright, like trust income, or other lump sums, things like that, that it's protected, because it's not, right? Because now you're outside of the protections of the trust. But sometimes that's enough for them to feel comfortable under those circumstances. Again, as uncomfortable as sometimes it can be for parties to talk about a prenup or a postnup, it can also be uncomfortable for a parent to talk to their child about it. It can cause some friction. You want to make sure you get invited to the wedding and that they talk to you. And I'm mostly just joking when I say that. It can be uncomfortable, but a lot of people do this and they get along just fine during the process. But it is something that I don't think people are necessarily thrilled to do. The issue with this alternative ends up being, the owner loses some control. So if it's not already there, they've likely already talked to their tax professionals, they've talked to their estate planning lawyers, they talked to their corporate lawyers about what these impacts are. But sometimes we ask that question, they're like, no, should I put it in there? It's like, I don't know, should you, right? It's just an initial call. And if they are going to do that, they have to think of those consequences as well. They lose a level of control. Tax implications can be different. So it's important, in that situation for the parents to talk to their professionals and make sure it's something that works with their goals, and what they already have going on. And again, depending on what the parent wants to prioritize, maybe the prenup is the best option, and that is a conversation with them, because it's not in a trust. They've thought about it, but they don't want to lose control over it. They want to keep it, the way it is, and the prenup kind of works in that sense. Last, if that parent doesn't have a proper trust set up, or that caller might be a business partner who's saying, hey, I am, half a 2-member LLC. My partner is getting married. I don't really know about this person. What's happening? And the conversation isn't a lot of the same. But the other question is, well, what do your corporate formation documents say? Does it provide for what happens if an owner dies? Does it provide for what happens if there's going to be transferability, if there's going to be a divorce? Often death is provided for. You don't always see divorce, probably less rarely. What you often see is there's some sort of right of forced refusal if an interest is going to be transferred. There's a weight of value and interest, and that's all relevant in the divorce context if you have a corporate document that says what the value is. So if those concerns exist, that can be covered. And again, it's that same conversation of this is very unlikely this will happen, but it is a way to protect it. And again, it goes to the point of conversation, having the right professionals involved. And if it's something people want to take into consideration, but if they do, and the concerns are already addressed, again, trust or the corporate documents itself is kind of that first step to make sure that you're looking at what actually makes sense. And if you have some concerns about how is this going to impact the relationship, that can kind of help address that. So as we're getting to the end of the presentation, I wanted to end with 4 takeaways. So first, assess the need for a prenuptial or postnuptial agreement. You can to protect the assets. Do you actually need it? And depending on the circumstances, it may not be needed, and that's not worth the unintended consequences on the relationship. But timing can be important, so that's why assessing it sooner rather than later makes sense, especially if you do have these other instruments and you kind of need to talk to a few different people. You want to have that conversation sooner rather than later. Second, if there is a need, and again, you might even be assessing this with that first takeaway, look at the other existing instruments to see if the concerns are already addressed in a trust, in corporate documents. And third, involve professionals as needed, tax, financial, the corporate lawyer who drafted the documents or works with you closely during the business. Same with estate planning professionals, anyone else that kind of helps you operate the business, and these different pieces of a financial plan in general should be looped in to make sure things are getting addressed. There isn't any vulnerability. You're kind of crossing your T's, dotting your I's. And last, all the instruments related to the business or the party or a party's asset should work together. It could be an enforcement nightmare if there's conflicting provisions in the instruments. And so the person drafting the prenup or the postnup should have anything that exists, should have the estate planning documents, the corporate documents. Similarly, once it's executed, depending on what the terms are, corporate people, estate planning people, financial people, they should have it, but you also might need to be making changes. It's not uncommon, especially if there's a disparity in wealth, for there to be provisions that say, part of consideration is I'm going to maintain this minimum standard in my estate plan, or I'm going to give this interest in this LLC to them within a certain period of time. So it's important for those people to get into the loop and make sure that once the prenup's done, any of those important pieces to effectuate it are put into place. Does anyone have any questions? Yeah.
You mentioned the prenuptial time horizon need to be complete for it to be effective. Is there any kind of time horizon associated with post-nuptial?
Not really, and that's kind of what I kind of alluded to a little bit about enforceability. So our law on prenups and postnups is fairly limited. If you're dealing with this issue, you can probably read all the cases in a short period of time. There's just not that many of them. So the timing for prenups, there's no like bright line rule, and it's a totality, but we typically say best practices, make sure it's executed within 30 days of the wedding. And you have all these terms in the prenup that's consideration, but a big part of the consideration in and of itself would just be that they're already married. And so when you have a postnup, you don't have that consideration. In our case, we have one case of postnups. We don't have a statute on postnups like we do prenups. So the case we have essentially just says, at least in this case, we're going to enforce this postnup, and we're going to say all the stuff we say about prenups that applies to postnups. But so you don't have the same trigger mechanism, right, in terms of timing. So a lot of times it's just a matter of they want to get it done for this reason. And so we just kind of get it done when we can get it done. If though there was something specific, like maybe the business was coming, and so you probably would want to get it done before that transfer, that succession occurs. Certainly if someone is, thinking that, all right, I pulled the divorce, we're going to try to, work on this. And so we're going to do a postnup. there might just be a little bit more pressure because you kind of want to get it done and so that you guys can move forward and try to kind of rebuild the relationship, but there's no bright line rules just because of the nature of the contract itself.
Do you see instances where, you know, there's a effort to they create a valuation for the asset of the business, at the time of marriage, and use that as a benchmark for, you know, what the value or, you know, so basically, once you combine, marriage, whatever value the thing was prior to that is off of,
So there's kind of a few pieces to that. So when you do either of these agreements, but especially with a prenup, you do a full financial disclosure. So typically means you're exchanging with 3 years of tax returns that become part of the agreement, as well as asset and liability. And oftentimes the business value is not the same valuation you would get if you went to a divorce, because it's a little bit different. And so typically, you're disclosing that value anyways. And then to your question, I think is a matter of what happened. It's a $500,000 business when you marry. By the time you divorce, now it's 1.5 million. What happens to that increase? So typically people would say that's part of the separate property. So separate property is defined as the specific asset as well as any any replacement properties are common as well as any appreciation value. Other times, especially people when they've been when it's their first marriage, they don't have to worry about kids from another marriage. Or maybe if it's their first marriage, they still could. But if typically if it's their first marriage, they don't have children from prior relationships. They might be more generous, and it may be anything that appreciates during the marriage is marital property, although that piece of it is separate. And so it kind of gets, you kind of get to the point where it's a little bit more of a puzzle than just what's marital, what's separate.
I thought we had a question.
You're welcome. Thanks, Isaac. I saw that one too. Yeah. Good. Okay. Any other questions or comments? Anything anyone's found surprising?
Is it safe to assume that it's state specific? So someone has a marital prenup agreement in a state of Georgia that it's effective in another state, but bound by Georgia's law. Am I understanding that correctly?
Yeah, for the most part, that would be true. So for example, when we're drafting prenups, we will put a clause that, the prenup application is controlled under New York law. That being said, people move. I have cases right now where we're dealing with a state prenup. It's not uncommon. And so typically it does get divorced, or it becomes a matter of our choice of law. And typically what it means is you get an expert from the state that the prenup was drafted in to say, yes, this is enforceable, or no, this isn't enforceable, here's why. And so it becomes more of an expert issue.
Okay. That's
Mhm.
thank you.
Yeah.
Without like a prenup, would it fall on the jurisdiction of the state where the marriage license was? For
divorce? Yeah, so each state has their own jurisdictional rules on when you can bring a divorce. So in New Hampshire, if both people are living here, that's enough. If you've lived here for a year, that's enough. And then there's other pieces too. But typically it's most of the time it's where you're at when you divorce that controls. Each state is a little different, but. All right. Well, if you don't have any more questions, double check the chat, please. Thank you. There's my contact information. For those of you who are here, I also have cards. So feel free to grab some on your way out, or we can pass it around. So it's not super easy to do it this way. But thank you guys for coming and listening. And feel free to take some of the breakfast items, stick around and chat and network a little. Thank you.